welcome to Crime in Court. My name is Heather, and this is one of the many episodes that I have in my playlist for the Canton Cover-Up, the Commonwealth versus Karen Reed, and we also talk about Aiden Turtleboy Carney. The Commonwealth is after him unjustly as well, in my opinion. And in this episode, it is episode number 66 of my deep dive. We are going to talk, or read through rather, the motion to dismiss that came out today from Judge Canoni, and we're also going to read an interview between Turtleboy and a juror. A juror has finally spoken out to one of the or to someone. Like we've all been waiting for a juror to come forward and say something about their time and on the jury and, answer questions and tell us everything. So we've been waiting for this, and Aiden is the first one to get the interview, and they actually address that in the interview, which we will get into. But up first, I wanted to go through very quickly two really short clips. This first clip is, of course, we've already seen it is when Judge Canoni calls a mistrial. So we're going to just watch how it happens. Just think about, if you were the defense attorney, when did you have time to object to any of it? And also, yeah, just watch Bev. That's all I gotta say. And then we're gonna watch another clip, which is more so the right way to do it. So let me get us started here.
You be seated, closing session.
22117 Commonwealth versus Karen Reed.
All right, the jury is at an impasse. So we'll bring them in.
You rise for the jury.
Sorry, it was lagging a little bit, so I'm gonna take my screen off, but I think it should be good now.
Closing session, please be seated.
Paul O'Keefe.
All right, Mr. Foreman, I am in receipt of your note. Judge Canoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise for the court, please.
And goodbye. Okay. All right. We remember what happened. So it was that quick. It was she read the note and said, "I'm not going to do that. It's a mistrial. I'll see you in a minute. Goodbye." Get out of my court. And then the very next thing that happens after the jury leaves the room and they're back on the record, Canoni just goes right into scheduling, and they started scheduling like a post-trial hearing. I don't remember what it was exactly for, but they started scheduling things after that. So it was basically like, okay, back to business. We got to schedule stuff. Back to square one. No big deal or anything. Not like Karen spent $1 million or whatever on her legal defense for the first trial, but let's do it again because hung jury, because Bev's instructions were confusing and the jury didn't know what to do, or because they weren't given the opportunity to clarify what they were hung on. So this next clip I'm going to show you in 1 second. It's going to be the exact opposite of Judge Bev. So hold on, let me switch screens here. Okay, so this was, whoops, let me move that over. So this was, that's better. This was another Karen. So this was the Karen Swift homicide trial, and her husband was on trial for her homicide. So, which took place over a decade. I didn't follow this case. I wasn't watching, but this did happen just recently, and this is how this, when this judge, or how this jury, when this jury, I can speak words. This is how, when this jury came back to say that they couldn't reach a final verdict, this is how Judge Canoni should have handled this situation. So let's listen in.
Has the jury reached a verdict in this case?
No, Your Honor.
Do you feel like that it is likely that the jury, on continued deliberations, will reach a verdict?
No, sir.
So they can't reach a verdict. He asked twice, "Are you sure?" She didn't do that. She didn't clarify. I mean, obviously, the note that they sent back was very clear. Hold on, I think my dog's not going to come in. Sorry, her sunbathing schedule really clashes with my recording schedule, but she doesn't care. She's a defiant little one. So she'll go out and sunbathe, and I'll be calling her to come in right before I go to record, and she's like, I ain't moving. So then I have to wait to listen for her to knock on the door. She knocks or scratches, really, but it's funny. Anyways, sorry. So, sorry for the interruption. Yes, this is, again, this judge is saying or asking questions, asking clarifying questions to the jury regarding their statement that they are hung. So let's continue on.
Let me ask you this. Has the jury considered the highest level of the offense?
Yes, sir.
Oh, look at that. Has the jury considered the highest level of offense? So this person is probably charged with multiple counts, and there's a higher, more higher count, which would require a stricter sentence. So the sentencing is different with the different offenses, obviously. So yeah, we need to know which offenses you're hung up on. Let's see what they say. Let's go back a second.
This. Has the jury considered the highest level of the offense?
Yes, sir.
Is there disagreement as to the highest level of offense?
Yes.
That's where your disagreement falls.
No, I'm sorry. It is not. That is not the case for the highest offense.
Okay. Does the jury agree on the highest level of offense, that the defendant is either guilty or not guilty?
Yes.
What is the verdict in that?
Not guilty.
Well, not guilty. So he asked, is this person, did you reach an agreement? Yes? Okay, great. What is your verdict on that? Let's watch it again, just for good measure.
Level of the offense?
Yes, sir.
Is there disagreement as to the highest level of offense?
Yes.
That's where your disagreement falls.
No, I'm sorry. It is not. That is not the case for the highest offense.
Okay. Does the jury agree on the highest level of offense, that the defendant is either guilty or not guilty?
Yes.
What is the verdict in that?
Not guilty.
Okay. So the
Not
jury has
guilty.
found the defendant not guilty of first-degree murder.
Yes.
Not guilty of the highest offense, which is first-degree homicide in this case.
Okay.
Not guilty.
Has the jury considered the second level of the offense attempted first-degree premeditated murder?
We did consider that.
Is there an agreement that the defendant is not guilty as to that offense?
Yes, sir, there is an agreement.
I have not asked you specifically, but are all of these agreements unanimous as to these levels of charges?
Yes, Your Honor.
Okay. Has the jury considered the charge of voluntary manslaughter?
Yes, sir.
Is there an agreement, or has the jury found the defendant not guilty of voluntary manslaughter?
There was no agreement.
No agreement?
No
Is that the
agreement.
level of the offense at which there is disagreement? Has the jury reached?
And that's the end of that. So, was there agreement on the first verdict? Yes. And what was the verdict? Not guilty. So, not guilty on first-degree homicide? Yes. Okay, moving on. What was your verdict? Or were you, did you come to a unanimous verdict on the second count, which I don't know what it was in this case. Let's call it manslaughter for good measure, because that's what Karen's second charge was. And they come back and say, no, we didn't reach a unanimous. He says, okay, so this is where you're hung up at? Yes. Okay, so hung jury, mistrial, only on that count. So he can't be charged again for first degree homicide. They can come back at him for the manslaughter or whatever the second degree charges are, or secondary charges were, whatever they were here. I don't know, but this is just an example of what Bev should have done. So, yeah, we'll leave it at that. Let me hold on one sec. Let me grab my documents. All right, so now let's get started reading the memorandum of decision and order of defendant's motion to dismiss. So this is Judge Cannoni's denial, and this is her reason why. We're not surprised that she denied, because most of us probably thought she would, but even so, we still all had some hope that she might at least, for good measure, bring the jurors in just to make it look like she cared about justice, but she didn't even do that. So we're going to see what she has to say in here and how little Judge Bev really cares for seeking justice in this case. So let's begin. All right. So on June 9th, 2022, a Norfolk County grand jury indicted defendant Karen Reed on charges of homicide in the second degree, which was charge 1, manslaughter while operating under the influence of alcohol, charge 2, and leaving the scene of personal injury and or loss of life, charge 3, following the loss of her boyfriend's life, John O'Keefe, on January 29th, 2022. Trial on the matter began in April 2024. So, yes, we had a two-month trial. It began in April. We ended with a mistrial shortly after July started, I think. So, no, it was the end. Well, we must have ended in like the end of June. There were 8 weeks of evidence and nearly 5 days of deliberations. We also had days where we didn't have trial, so that extended the length of time for this trial to take place. So after the jurors expressed to the court that they were deadlocked for a third time, the court declared a mistrial. The defendant now moves to dismiss the charges for second-degree homicide and leaving the scene of personal injury and homicide or loss of life, are arguing that retrial would violate the double jeopardy protections of the federal and state constitutions because the jury, in fact, reached a unanimous decision to acquit the defendant on those charges. And we have heard from at least 5 of the 12 deliberating jurors that have said this and confirmed that they were unanimous on charges 1 and 3 to acquit. And they've even come out and kind of had a little snark back at the Commonwealth for saying they've gone to reporters, Christina Rex, saying, hey, the Commonwealth, we reached out to them and they haven't gone back to us. So that is a problem. All right, so alternatively, the defendant argues that dismissal is required because there was no manifest necessity to support the declaration of the mistrial with respect to those charges. Right, there was no necessity because they did come to an agreement on two of the charges. So for those two charges, there was no necessity. For the um, second charge that they could not decide on, that's the one she could call a hung jury. That's the one that has a manifest necessity because they cannot decide. Anyway, so after careful consideration, this court concludes that because the defendant was not acquitted on any charges and defense counsel consented to the court's declaration of mistrial, which never happened. I don't know where she saw that happen, but she's now saying that the defense counsel consented to the declaration of a mistrial. So now double jeopardy is not implicated by retrial of the defendant. This motion is therefore denied. And we know that they are going to appeal this. Actually, before I forget, let's actually let me find his tweet I just saw. Sorry, I just wanted to make sure I have those tweets ready for you when we finish this reading. So when we finish reading this court document, I will have a couple quotes or comments that people said about it, and then we'll move on to Turtleboy's interview. So sorry, I just wanted to make sure that I had it ready. All right, so on June 25th, 2024, this is the background, the jury began its deliberations in the defendant's trial. In addition to the 3 indictments, the court had instructed the jury to consider 2 lesser included offenses to manslaughter while operating under the influence of alcohol, involuntary manslaughter, and motor vehicle homicide, OUI, liquor, and negligence. These were confusing as all get out, and I still don't understand them, and they shouldn't have been on there. And then I think that's what the jury got hung up on, was the confusing lesser included. I believe that's what one of them had, one of them had confirmed. But to me, that makes it seem like somebody just thought, like, well, she was drinking and driving, so she needs to be punished. So let's do this kind of involuntary manslaughter, even though there's no evidence that her car hit John O'Keefe. But moving on. So on Friday, June 28th, 2024, at approximately 12:10 p.m., the jury foreperson sent a note to the court. And it stated, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. The court requested argument from the Commonwealth and the defendant as to whether there had been due and thorough deliberation from the jury. Assistant District Attorney Lawley, on behalf of the Commonwealth, argued that the jury had not had sufficient time to deliberate, and therefore it was far too early in the deliberative process to give the jury the Tui-Rodriguez instruction. There's a footnote here. It says the use of the Tui-Rodriguez instruction is a matter of discretion of the trial judge. It is the orthodox approach to dealing with a deadlocked jury, see Commonwealth versus Furman, and designed to urge the jury to reach a verdict by giving more serious consideration to opposing points of view. So we learned from some of the jurors that they came back after the Tui Rodriguez was written, and some of them actually changed their verdicts to guilty on these lesser charges because of that Tui Rodriguez. They must have been like, oh, okay, I'll listen to my fellow jurors, and they caved in, or they felt pressured and bullied, which was another reason that we were given. All right, so he also pointed out that although the note indicated that the jury had not yet come to a conclusion, it did not indicate that doing so was not possible. Attorney Yannetti, on behalf of the defendant, disagreed with Mr. Lawley's characterization of the note. He argued the word exhaustive is the word that I think is operative here. The jury is communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and at an impasse. You know, this is the case where the jury has the legal instructions. They've only really asked one question, which was to try and get a report, and they were not allowed to get it. And I think that the message has been received that the evidence is closed and they won't get anything more. They've been essentially working nonstop over the last 3 days, 4 days. We're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is the jury should be read the Tui Rodriguez model instructions and go from there. That is what David Yannetti argued. The court ruled that given the length of the trial, the number of exhibits and witnesses, the complexity of the issues, and that the jury had only been deliberating for 3 days, deliberations had not been sufficiently due and thorough to warrant a Tui Rodriguez instruction. It instructed the jury to continue deliberating. On Monday, July 1st, 2024, at approximately 10:45 a.m., the jury sent another note to this court. The note said, "Despite our commitment to the jury," notice she doesn't quote herself. I just want to point that out. She just says that she calls herself meaning the court, instructed the jury to continue deliberating, but she doesn't give her instruction, like what her actual instructions were there, the verbiage. And I think that's kind of important because she had kind of a say in what that instruction was. She didn't want really input from David Unity about it, or her Karen Reed's team. All right, so on Monday, July 1st, this was the second note. Despite our commitment to the duty entrusted in us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. I don't think they do. Or the people that were really holding out for a guilty just really weren't paying attention. All right, so the court again requested argument from counsel as to whether there had been due and thorough deliberations. The Commonwealth argued that the jury had been deliberating 22 to 23 hours, but given the length of trial, number of exhibits and witnesses, and the complexity of issues, she keeps saying the same thing, they had not done a thorough deliberation up to this point. Attorney Yannetti again had a vastly different view. He argued, "Our view is that it is time for the Tui Rodriguez instruction. They have come back twice, indicating essentially that they are hopelessly deadlocked, but the content of this message is that they have been over all of the evidence. The previous message said they did an exhaustive review. This time they said that they have fundamental disagreements about what the evidence means. It's a matter of opinion. It's not a matter of lack of understanding. This court, when you sent the jury out, encouraged them not to take a straw vote, encouraged them to go over all the evidence in a very methodical manner. I think all instructions are that they have done that and that this is what the Tui Rodriguez is for." The court agreed that the jury had engaged in due and thorough deliberations, noting that this jury had been extraordinary, and it had never seen a note like this from a jury. Again, she's not really quoting herself here. She's quoting everybody else, but she's just saying the court agreed and said that. It thereafter provided the jury of the full Tui Rodriguez instruction and asked them to return to the deliberations with those instructions in mind. Before I read that citation, another thing that people noticed was, she chose the foreman before the two alternates were chosen. So basically, taking the foreman out of the alternate uh, out of the running for becoming an alternate juror. So basically, securing his position on the jury. So it's and he's also ex law enforcement or former law enforcement. So it's very concerning, I think, that she chose juror one to be the foreman when other people have come out and said, I've been a jury member in Judge Cannoni's court before, and she never picked the jury there or the foreman there. So it's just very odd that she did pick a foreman and said, okay, juror number one, you're foreman, which, so, a lot of lawyers will say, that can happen, but, it's not totally out of the realm for a judge to do that. But to do that before the alternates were chosen, that's a problem to me. And he also is presumably possibly the one that uh, wrote some of these notes and also was part of the possibly he was juror C, I want to believe, or I can't remember what letter he was, but he was the one that came out with the please suppress all of our names indefinitely. I am terrified because of a blogger. So we read through his motion to keep their names private, all the jurors' names and information. All right. So, anyways, let's read this. Oh, geez. Do we really need to read this jury instruction? We read it before, but let's remind ourselves. All right. So, the Tui Rodriguez instruction states our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking, in all cases, absolute certainty cannot be obtained, nor is it expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusions of other jurors. So don't just give in to other jurors, basically. It needs to be your own thoughts, your own opinions, what you think. Still, in order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with proper regard and respect for each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any future jury would be selected. There is no reason to suppose that this case will ever be submitted to 12 persons who are more intelligent, more partial, or more competent to decide it than you are, or that more or clearer evidence will be provided or produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. That right there should be okay, not guilty on all counts. They did not meet their burden. If you are left with a reasonable doubt to any essential element of any indictment, then the defendant is entitled to the benefit of the doubt and must be found not guilty on that indictment. So, therefore, not guilty on all counts. Um, where was I? Should be found not guilty on that indictment. In conferring together, you are to give proper respect to each other's opinions and listen with an open mind to each other's arguments. So I want to point out after reading that sentence that this is the reason why people started getting mean and bullying each other in the verdict or in the deliberation room, as we were told by one of the jurors anonymously that there was some bullying going on. Actually, I think that was in a court filing. But still. So, and she just said, be respectful of one another and don't be mean. Listen with an open mind. All right, so where there is disagreement, those jurors who would find the defendant not guilty should consider whether the doubt in their minds is a reasonable one if it makes no impression on the minds of the other jurors who are equally intelligent, who have heard the same evidence with the same attention. I probably need to move this. I can't scroll up. Oh yeah, I can. Here it is. Sorry. Um, with the same attention, who have an equal desire to arrive at the truth, and who have taken the same oath as jurors. As this at the same time, these jurors who would find the defendant guilty ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. So basically, look at your verdict and question it. Does it make sense based on what the people of the opposing side say? Look at what the opposing side says and be respectful. They should ask themselves whether they should distrust the weight of or sufficiency of the evidence if it has failed to convince the minds of their fellow jurors beyond a reasonable doubt. That was long. All right, so the same day at approximately 2:30 p.m., the jury sent another note to the court. The court stated to counsel that the jury was at an impasse. After the jurors filed in the courtroom, the court read the note. Despite our rigorous efforts to continue to find ourselves at an impasse, we continue to find ourselves at an impasse. And this is what I just played for you in the clip, but we'll read it again. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. And it's curious that that's first, because I think these notes were written by that foreman, and he's looking at it with a she's guilty lens, I think. So he puts that first. Like, some of the members of the juries find that the burden of proof was met, surpassing the burden of proof, whatever. All right, conversely, others find the evidence fails to meet the standard. So he's just like, blah, it fails to meet the standards, but here it surpasses the burden of proof. Like, he's got to throw in like, they did their job immensely type of thing. All right, so conversely, others find that the evidence fails to meet the standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. After reading this note, the court declared a mistrial and discharged the jury back to the deliberation room to wait for the judge. I want these jurors to come out and tell us what happened in that room, because what was said? Did she tell you not to talk? Did she tell you? I don't know. What did she tell you? Please let us know. Counsel remained in the courtroom to discuss an agreeable date to return for a status conference. So that's what they were scheduling. Was a status conference, which they already had. So on July 8th, the defendant filed the instant motion to dismiss, supported by affidavits from Attorney Yannetti and co-counsels. Attorney Jackson's affidavit stated that on July 2nd, a juror in the case, Juror A, contacted him. Attorney Jackson was able to identify the person as a deliberating juror based on his or her description of who he or she is, where he or she was seated, and certain identifying information, name, and occupation disclosed during the voir dire process. According to Attorney Jackson's affidavit, Juror A told him that he or she wished to inform him of the true results of the deliberations because he or she believed that those results significantly impact the defendant's rights. Juror A said that the jury unanimously agreed that the defendant was not guilty of counts 1 and 3, and specifically that the homicide charge was off the table. First Jackson affidavit at paragraph 5. In this affidavit, Attorney Jackson also stated neither Ms. Reed nor her counsel consented to the entry of this mistrial. Defense counsel was denied the opportunity to request that the court inquire on which count or counts that the jury may have been deadlocked, including the lesser included offenses, and on which count or counts the jury may have arrived at a verdict. Attorney Yannetti's affidavit averred that on July 3rd, he received communication from two informants who had received information from two deliberating jurors in the case. The first informant, we'll call them Informant B, sent him a screenshot that he or she had received from someone else, Intermediary B, of text messages that Intermediary B had purportedly received from a juror, Juror B. Attorney Yannetti averred that he was able to positively identify which juror was Juror B based on a first name given to him from Informant B. In the screenshot, Juror B texted Intermediary B. It was not guilty on second degree and split in half for the second charge. When the judge sent us back with the Hernandez, they mean the Tui Rodriguez charge, to look at the other side, it turned into a bully match. That's where they said it. And yes, this was in Attorney Iannetti's affidavit from the intermediary, talking about what the intermediary received from the informant, which it's all like layer upon layers, hearsay upon hearsay, but it still is corroborated by other things that have been said. So when the judge sent us back, it was a bully match. I thought the prosecution did improve the case. No one thought she hit him on purpose or even thought she hit him on purpose. And later that was corrected to say or even thought she or even knew that she hit him, meaning like if she did hit him, like she wouldn't have known that she hit him. So that's that. Attorney Yannetti stated that another informant, Informant C, contacted him on July 3rd. Informant C told him he or she personally knows a juror, Juror C, and the informant C and Juror C have a mutual friend, Intermediary C, who is a current coworker and a friend of Juror C. So I'm not even going to try to explain that. Just try to keep up. Just know it's hearsay upon hearsay. All right, so Intermediary C told Informant C via text message that Juror C was a deliberating juror in this case. Intermediary C had a discussion over text message with Juror C about the experience of being a juror. Intermediary C said that Juror C said there was no consideration for homicide 2, the second degree homicide. Manslaughter started polling at 6-6, then it ended deadlocked at 4-8. 4 no, 8 yes. And then we also heard that it was 9-3, so there's different things being said about that, but it is still, about in the same ballpark that it was 4-8 to 9-3 to convict her on manslaughter, which just baffles me that 8 or 9 people actually got there. But moving on. So Informant C texted back, interesting. If there was no consideration for homicide 2, shouldn't she have been acquitted on that count and hung on the remaining charges, I think they meant to say, goes back to the jury slip that was confusing. Intermediary C texted, she should have been acquitted, I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. Did I miss a? Oh, I missed a note here, a footnote. As noted below, defense counsel argued to the court that the verdict slipped for indictment 2, which allowed the foreperson to check guilty for the lesser included offenses, would be confusing for the jury if they decided the defendant was not guilty of all lesser included charges. So she's putting it on the record that the defense did say that they were concerned about this page. So that doesn't help her case any if this goes to a Supreme Court. it's pretty much showing that she was pretty incompetent here with her jury instructions and the jury form. Attorney Yannetti stated that based on the description of Juror C he received from Informant C and the description of what Juror C told Intermediary C, he could positively identify the juror was a deliberating juror. Attorney Yannetti later filed a supplemental affidavit in support of the defense's motion to dismiss, wherein he stated that he received an unsolicited phone call from an individual identifying himself or herself as Juror B. Juror B told Attorney Yannetti that he or she was familiar with the affidavit that he had previously filed and confirmed the substance of the conversation between Informant B and Intermediary B. So Juror B confirmed what the intermediary said. Juror B clarified that he or she meant to write, "No one thought she hit him on purpose or even knew that she had hit him," if that's what they believed. Uniti's supplemental affidavit on paragraph 4. All right, so on July 10th, Attorney Jackson submitted a supplemental affidavit stating that on July 8th, another juror, now Juror D, so Juror C is the one that wanted to protect their anonymity and put that motion forward to seal their names and contact information and whatnot from the public, and she did indefinitely. So I guess we don't get to ask our jurors anything about their jury deliberations unless they come to us. So there's that. All right, so on January 10th, Jackson filed this other supplemental affidavit for Juror D. He identified his person or this person as a juror by the description of who he or she is, where he or she was seated, and certain identifying information, name and occupation disclosed during the voir dire process. Juror D told Attorney Jackson that he or she was uncomfortable with how the trial ended. Juror D, now a fifth juror to come forth, no, fourth juror to come forth, and yeah, saying that the way that Bev handled the mistrial also left them feeling uncomfortable. Juror D said that it was very troubling that the entire case ended with the jury being asked, not, let me retry that. Juror D said that it was very troubling that the entire case ended without the jury being asked about each count, especially count 1 and 3, because those are the ones that they acquitted. According to Jackson's supplemental affidavit, Juror D told him that the jury agreed that the defendant was not guilty on counts 1 and 3, and they disagreed solely on count 2, the lesser offenses, but that they believed that they were compelled to come to a resolution on all counts before they could or should report verdicts on any counts. So right there, again, she's putting it, Judge Canoni is putting it on the record and agreeing or consenting that the jury has said it was confusing. They didn't know what to do. They disagreed on the lesser charges, but they believed that they were compelled to come to a resolution on all counts before they could or should report verdicts on any counts. And that is Judge Canoni's instructions. They believed they were compelled, blah, blah, blah. I hate these things. Why do these stupid bubbles come up? All right, so Juror D believed that all jurors would corroborate his or her account. He said, or he or she also stated that if necessary, he or she would testify before the court as long as his or her identity was protected. So all these people are scared to come forward because they've seen what the McAlberts and crazy clan mates can do. Look at what we've gone over in this channel. People that live in the town of Canton that support John O'Keefe and Karen Reed, They get their lawns, they get toxic chemicals thrown on their property and ruin their lawns and vegetation and vegetables and flowers, and it's despicable. And the Canton police haven't come forward. Helena Rafferty has not come forward to condemn those actions. So, and I'm sure they're not really investigating who did it, but somehow they found out it was like some toxic chemicals that you can't even like. They first thought it was bleach, but it's not bleach. It's something even worse than bleach, apparently. So that's crazy. So there's just so much going on in this town that is not no the people aren't being protected. The jurors' identities need to remain protected because the crazy McAlbert clan will come after them. All right, so on July 18th, Attorney Jackson submitted a second supplemental affidavit stating that on July 17th, he was contacted by yet another juror. This is now our fifth juror, Juror E, who who has identified by the description of who he or she, where he or she was seated, and certain identifying information, name and occupation, disclosed during the voir dire process. Juror E also stated that the jury was unanimous on counts 1 and 3, that the defendant was not guilty of those charges, and that they were deadlocked on one of the lower charges on count 2. Jackson's second supplemental affidavit, paragraph 5. On August 1st, the Commonwealth filed a post-trial notice of disclosure stating that ADA Lally had received 2 unsolicited voicemails from an individual identifying themselves as a deliberating juror stating that the jury had been unanimous on counts 1 and 3. So she is putting it on the record that Adam Lally received these calls. This is a huge, huge violation of Karen Reed's civil rights, and this is going to get turned over by Superior Court, no doubt. Just no doubt. She's even admitting that these things happened, that Adam Lally received 2 unsolicited voicemails from a juror saying that they acquitted on counts 1 and 2. This is ridiculous. She's admitting it in court filings. This is Judge Canoni writing the background. So she's admitting it happened. They're not denying it, but yet, ugh, okay. I don't know, because she hasn't addressed this yet. So, in its response to the emails, the Commonwealth stated that it was ethically prohibited from inquiring as to the substance of the jury deliberations and that it could not promise confidentiality as it may be required to disclose the substance of any conversation to the defendant or the court. That's not the anonymity that they need. They need anonymity from the public, from the McAlberts. They want to remain protected from the public. I'm sure they don't care if Karen Reed knows and the court knows that they came forward. I'm sure that's okay. All 3 jurors declined to communicate further with the Commonwealth. Yeah, they declined to communicate further because you guys were giving them a runaround and probably told them, well, we can't protect you, so bye. Get out of here. They can absolutely protect. Why did she seal their names then if they can't protect them? Have them come in to a closed hearing or open to the public, but at least, not televised, and question them. I just don't understand why this is so hard. Why Judge Bev is making it so difficult. Moving on. The Fifth Amendment to the United States Constitution, applicable to the states through the 14th Amendment to the United States Constitution and Massachusetts common and statutory law, protect an individual defendant from being twice placed in jeopardy for the same crime. The Double Jeopardy Clause affords a criminal defendant a valued right to have this trial completed by a particular tribunal. Citation omitted. A defendant is entitled to protection from double jeopardy if there had been some event such as an acquittal, which terminates the original jeopardy. Okay, Bev, bias Bev, corrupt Canoni, as I'm calling her, bias Bev or corrupt Canoni. Um, this is an outrage. I'm outraged. She has been acquitted. You just don't want to hear it. You don't want to believe it. So you're ignoring it and sweeping it all under the rug. The jurors have come out publicly, 5 of them, saying that she was acquitted on these charges. And yet, Judge Bev is going to dig deeper into the sand and say, nope, she's not acquitted. I say two on my citizens, my meager citizens of my land. I don't care what anybody says or does. I spit on you all. That's what I think, Judge. That's what I think of Judge Canoni. She's like a queen in her kingdom, and she's just like, screw everybody. I don't care. All right. So, double jeopardy. She is going to, if a defendant is entitled to protection from double jeopardy if there had been some event, such as an acquittal, which terminates their original jeopardy, or if a mistrial is entered without the defendant's request or consent unless there was a manifest necessity for the mistrial. Again, you're not seeing the point. There was a necessity for the hung jury on charge 2, but for counts 1 and 3, no, there wasn't. So they have claim for both of these, I think. The defense does. All right, so blah, blah, blah. In her motion to dismiss, the defendant argues that retrial on indictments 1 and 3 would violate the double jeopardy protections of the federal and state constitutions because, despite absence of a jury verdict, the jury, in fact, reached a unanimous decision to acquit her on those charges. No, they didn't. Or alternatively, because, I mean, yes, they did. Sorry. They reached a unanimous decision to reach her on all those charges. Yes, they did. Or alternatively, because there was no manifest necessity to support the declaration of the mistrial with respect to those charges. No, there wasn't in respect to charges 1 and 3. After careful consideration, the court concludes that the defendant's arguments are without merit. God, I hate this woman so much, and I know it's so wrong to hate, but I cannot stand Canoni. She needs to get off the bench. All right, so number 1, acquittal of the defendant. The defendant first contends that she was acquitted on indictments 1 and 3, and that therefore retrial is barred based on the attorney's affidavits purporting to reflect statements by jurors that the jury reached unanimous conclusion that she was not guilty on those charges. Although all the statements in the affidavits are from purported jurors who wish to remain anonymous for the purposes of this motion, the court accepts the statements as true and accurate. The court accepts the statements of those jurors as true and accurate. While the court accepts the averments as true and accurate, it disagrees with the defense counsel's characterization of the statements as strong and uncontradicted. The substance of the conversations directly contradicts the notes that the jury wrote in the court during deliberations, the last of which expresses disagreement over whether the Commonwealth met its burden as to the element of the charges with an S, she says. Okay. Even so, an agreement among the jurors as to counts 1 and 3 cannot be considered acquittals for purposes of double jeopardy. To trigger double jeopardy protection, an acquittal requires a verdict on the facts and merits, citations and quotations omitted. A person shall not be held to answer on a second indictment or complaint for a crime of which he has been acquitted upon the facts and merits. And the only verdict which can be received and regarded is a complete and valid verdict of a jury is an open and public verdict, affirmed in open court as the unanimous act of the jury and in presence of the whole panel, so that each juror has an opportunity to express his consent to the court in case his decision has been mistaken or misrepresented by the foreman or his fellows, or in case he has been forced to acquiescence by improper means. So basically, because they still want to remain anonymous, she's not allowing them to put their verdicts on paper to make it public. Okay, because they want to remain anonymous. So we can't have them come in and question them on their verdict because you guys effed up. No, not possible. Okay, moving on. The verdict shall be unanimous. It shall be general verdict returned by the jury to the judge in open court. The jury shall file a verdict slip with the clerk upon the return of the verdict. As such, the weight of the final adjudication cannot be given to any jury action that is not returned in a final verdict, and a distinction must be made between agreement on a verdict and return receipt and recording a verdict. Okay. Because there was no open and public verdict affirmed in open court rendered in this case, the defendant was not acquitted on any of the charges. So says her. The only unanimous act of the jury here was their representation to the court that they were at an impasse and unable to agree on whether the Commonwealth had established beyond a reasonable doubt the elements of the charges. This is this is getting my blood raging. All right, so the purported later attestations by some jurors after they had been dismissed that the jury had in fact agreed in some of the charges during deliberations do not have the force of a final verdict. Yeah, okay, we're not saying that they do. So bring them in, ask them. You know what? So what if they don't want to be unanimous? Make it public. Force them to come and attest to what the stuff was. If you really can't give them anonymity, which I highly doubt, then bring them in. The judge has the power to do so and ask them, affirm this, because this is unprecedented. So for her to just say, oh, well, whatever, it wasn't done in court because I forced them out of my courtroom so fast that they had no time to ask questions about each charge, then, it's just, oh, it's so ridiculous. All right. So, da, 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 da. After mistrial was declared due to a deadlock in this particular example, the judge did not err in refusing to accept signed verdict slips recovered from deliberation room showing not guilty because it is not enough to show that the jury may have agreed on some issues at some time. If that limited showing were to control, uncertainties would be invited. So this is like some old case that I guess they found some jury slips where there was a not guilty in the jury room, but because they didn't do it in open court, it didn't count. So she's using that as an example. That's this Bluford versus Arkansas, and that is an old case. Double jeopardy did not bar retrial after a hung jury where four-person reported unanimous vote on offense before deliberations had concluded but deadlock at conclusion. The defendant argues that it is elevating form. Yeah, okay. So the defendant argues that it is elevating form over substance to not accept that the statements in the affidavits reflect an acquittal on the defendants on counts 1 and 2. Not only that, but it is basically just totally discounting the jury and all their hard work that they put in and the 10 weeks that or 9 weeks that they gave up to be a part of this jury. And she's just totally discounting that. She said they're true, but she's saying she they don't matter. She agrees that it's true, but that it doesn't matter is what she's saying. She's like, I don't care. They're true, but I don't care. We're still gonna say it's a mistrial because I didn't give them the opportunity to do anything about it. Okay. However, the rendering of a verdict in open court is not a ministerial act. Ministerial. What does that mean? Hold on. So, in legal terms, ministerial actually means an act or duty that is prescribed by law and performed in accordance with legal authority. It also means following instructions or laws without using personal judgment or skill. For example, a court clerk's ministerial duties include recording judgments on the docket. Other examples of ministerial acts include a um, notary public. I said republic. Yeah, a notary public notarization, a clerk of the court entering a court order. So just an act or duty that is prescribed by law. So things that they need to do by law. So that is what ministerial means in legal terms. So, however, the rendering of a verdict in open court is not a ministerial act as the defendant contends. Rather, it communicates the finality of the deliberations, and its pronouncement in open court ensures its uni- unanimity. Words are hard. All right, so public affirmation is in open court provides safeguards against mistakes. Well, right. So I would like to say she should bring them back to open court in her using her own argument. Public affirmation in open court provides safeguards against mistakes. Why don't you bring them in a public court and ask them what their verdict was, if it was unanimous on counts 1 and 3 for not guilty? If so, then she's making a mistake by not bringing them in and asking them that and clarifying for the record. She's making the mistake, but I think she fails to see that here. Indeed, the authority upon which the defendant relies places particular importance upon the jury's pronouncement of its findings in open court. See Bluford. Something arguing. Uh, so in this Bluford, somebody arguing that the forewoman's announcement in open court that the jury was unanimous against conviction on capital and first-degree homicide was an acquittal for double jeopardy purposes. 5. In written and oral argument, the defendant also relies on language from Taylor. Taylor discussed whether a judicial determination to terminate proceeding based on a procedural ground implicated double jeopardy. The Supreme Court and the Supreme Judicial Court explained what constitutes an acquittal is not to be controlled by the form of the judge's actions, and that the determination does not depend on the check marks on the form. A little gnat flying around. So yeah, so again, I say that this hurts her. The Well, she's arguing that it's not comparable or whatever, but it's saying the acquittal, what constitutes as an acquittal, is not to be controlled by the form of the judge's action. So the judge, whatever the judge did wrong, uh, we need to correct that. Anyways, all right. Where was I? So 5. Thus, a verdict in substance is a final collective decision reached after full deliberation, consideration, and compromise among the individual jurors, and when the decision is announced in open court, it becomes entitled to full double jeopardy protection. So, because it wasn't said in open court, because she didn't allow it to be said in open court, they're going to try a woman who has already been acquitted on 2 counts for the same thing. Something citing Commonwealth versus Ross, declining to give effect to the verdict received from the lips of the foreman in open court would elevate form over substance. Where there was no verdict announced in open court here, retrial of the defendant does not violate the principle of double jeopardy. God, she is infuriating. Manifest necessity of mistrial. The defendant's motion to dismiss also argues that double jeopardy bars re-prosecution because she did not consent to a mistrial and there was no manifest necessity to declare one. This argument, too, is without merit. A defendant's consent to a mistrial removes any double jeopardy bar to retrial. According to Pellegrin versus Commonwealth, consent may be explicit or implicit. Explicit consent may occur by either moving for a mistrial or agreeing to one. Commonwealth versus Edwards. Consent to a mistrial may be implied where a defendant had the opportunity to object to a declaration of a mistrial and failed to do so. So that means they consented, obviously, because she rushed them out of there and didn't give the defense a chance to talk. But it's their fault. Where the defendant sits silently by and does not object to the declaration of a mistrial, even though he has a fair opportunity to do so, a court may presume his consent. See also United States versus U. A court may infer consent only where the circumstances positively indicate defendant's willingness to acquiesce in the mistrial order. Consent to a mistrial need not be expressed, but may be implied from the totality of the circumstances attendant on a declaration of a mistrial. Well, that's fine, but because, I mean, they were willing to call it a mistrial if that's indeed what it was, but they didn't know because you made it impossible for the jury to tell you that they reached a verdict on 2 counts. Am I going insane here? I feel like I'm insane, or I don't know. I can't be the only one looking at it this way. All right, so as noted, the court here declared a mistrial after the jury reported 3 times that they were deadlocked. After the second time, the court determined that the jury had engaged in due and thorough deliberations and gave the Tui Rodriguez instruction before sending the jury to deliberate further. Massachusetts General Law 234A 68C provides that if a jury, after due and thorough deliberation, returns to court without having agreed on a verdict, the court may state anew the evidence or any part of the evidence, explain to them anew the law applicable to the case, and send them out for further deliberation. But if they return a second time without having agreed on a verdict, they shall not be sent out again without their own consent, unless they ask from the court some further explanation of the law. So she couldn't have sent them back after the Tui Rodriguez to deliberate any further. See Commonwealth versus Jenkins. If after due and thorough deliberation, the jury twice advised the judge that they are unable to reach a verdict, the judge may not properly send the jury out again without their consent unless the jury asks for some further explanation of the law. In their note to the court, the jury specifically stated to continue to deliberate would be futile and only serve to force us to compromise those deeply held beliefs, making it clear that they would not consent to continuing their deliberations. Attorney Yannetti twice argued for the court to give the Tui Rodriguez instruction, the final step before the court would declare a mistrial. and that's Ray versus, oh, that's also Jenkins and Ray versus Commonwealth. Counsel's request for Tui Rodriguez instruction permitted the inference that both parties were provided an opportunity to be heard on possible alternatives to a mistrial. Okay, but isn't it Judge Cannoni's responsibility to determine those alternatives and to take every other step imaginable before you call a mistrial? But she seems to have a record of mistrials. She doesn't care. It's not her money or her time being wasted or her freedom or anything like that. It's just the defendant's. No big deal. Specifically, on Friday, June 28th, 2024, after 3 days of deliberations, when the jury sent their first note indicating that they had engaged in an exhaustive review of the evidence and had been unable to reach a unanimous verdict, Attorney Yannetti argued that the jury had engaged in due and thorough deliberations, was at an impasse and should be given the Tui Rodriguez instruction. The following Monday, when the jury sent a second note after deliberating for approximately 2 hours, stating that consensus was unattainable, Attorney Yannetti again argued that due and thorough deliberations had occurred and described the jury as hopelessly deadlocked. Defense counsel, uh, in arguing twice that due and thorough deliberations had occurred and pushing for the instruction, presumably was aware of the legal implications if the jury returned deadlocked again. Nonetheless, in a remarkable turnaround, defense counsel now argues that the result they hold on, my dogs are going to be loud for a second. Sorry. Start that over. All right, so defense counsel, in arguing twice that due and thorough deliberations had occurred and pushing for the instruction, presumably was aware of the legal implications if the jury returned deadlocked again. Nevertheless, in a remarkable turnaround, defense counsel now argues that the result they twice advocated for was sudden and unexpected. Although the court did not specifically ask defense counsel if they had any objection to the declaration of a mistrial, counsel had multiple opportunities to voice an objection if they, in fact, had one. Well, how? Okay. First of all, they didn't know that they were objecting to, or they didn't know that they had to object to all three mistrials, I mean, all three charges. So, for, them coming back hung. They didn't know because Judge Bev never clarified and she shooed him out of the room as fast as she could. So counsel had multiple opportunities to voice an objection if they had one. I don't agree with that. While waiting for the jury to enter the courtroom after the court announced the jury was again at an impasse on the afternoon of July 1st, 2024, defense counsel could have asked to be heard on the issue. Um, no, because they came, as soon as the jury left and they resumed, Judge Bev was like, okay, let's schedule a hearing for a status hearing, whatever, blah, blah, blah. So, I mean, she didn't even give them an opportunity. I mean, I guess they could have said something, but I think they were just as stunned as everybody that it was a mistrial and not an acquittal on all three counts. Anyways, all right, so while waiting for the jury to enter the courtroom, after the court announced the jury was after the court announced the jury was again sorry. While waiting for the jury to enter the courtroom for the court, and why am I struggling with words today? While waiting for the jury to enter the courtroom after the court announced the jury was again at an impasse on the afternoon of July 1st, defense counsel could have asked to be heard on the issue. During the subsequent discussion about scheduling a status hearing right after the court declared a mistrial, counsel had yet another opportunity to inform the court of its dissatisfaction. Lastly, so she's putting it all on the defense, saying they erred because they didn't say something at that time, even though they were never given an opportunity and there was never any clarification on the mistrial itself. And she does, or on the what they were hung on, and she didn't try to clarify anything. She just got him out of there as fast as she could. During the subsequent discussion, oh, sorry. So, lastly, counsel could have communicated to the court any objection or request to poll the jurors while the jury was still at the courthouse waiting in the deliberation room after the declaration of the mistrial. Instead, defense counsel said nothing to the court about the mistrial and then proceeded to the courthouse steps where Attorney Jackson declared to the media and onlookers that the Commonwealth failed miserably and will continue to fail with its prosecution of the defendant. And she provides a YouTube clip. It strains credulity to believe that if defense counsel wanted to voice any objection to the court, it would not have been heard. Significantly, defense counsel were no shrinking violets, she calls them. Is this even, I mean, Ha this is so inappropriate to put in a filing. They were no shrinking violets. Like, they didn't just sit down and shrink up when they needed to, when I needed to control the courtroom. God, I hate her. Okay. So neither Attorney Jackson nor Attorney Unetti has ever needed this court to inquire whether counsel had an objection in order to be heard, and the court has never denied counsel the opportunity to be heard in open court or at sidebar. The court reconvened many times at counsel's request. Just days before the declaration of mistrial, defense counsel asked to address the court while the jury was deliberating to raise an objection about the verdict slip. Now she's going to like give them shade about this too. Attorney Attorney Jackson was not shy in informing the court that he wanted to make his argument and that the court's decision about the verdict slip, why do I keep saying slipped? Slip was not how it should be, and it's over our strong objection. And there's a YouTube clip for that footnote. Okay, so Attorney Jackson went so far as to suggest that it sorry, this is blurry and hard to read, and my eyes suck as it is. Attorney Jackson went so far as to suggest that it was almost like the court is directing a verdict of the subordinate charges by not making changes he wanted, which it did almost seem like they were trying to direct a guilty verdict on at least the manslaughter, because that's the slip that was really messed up. The court finds it hard to believe that when counsel heard that the jury was at an impasse for the third time and a mistrial was inevitable at perhaps the most crucial point in the trial, counsel would sit silently if they did not consent to a mistrial. Well, okay, so what are they going to do if the jury can't decide on, like, so what if you object? Like, what does that mean? If you object, it doesn't matter because, do you see what I'm saying? Like, if everybody was not able to come to an agreement, then why wouldn't they consent to a mistrial instead of, if everyone was not able to come to an agreement on all charges but two, and they came to an agreement on those two, but the one charge they didn't, are you going to object? Well, yeah, because yeah, it's not a mistrial, but she didn't ask. Do you see what I'm saying? It doesn't make, her arguments don't make sense to me. As such, the court does not credit Attorney Jackson's averment that he lacked an opportunity to be heard. He absolutely did. She kicked them out of that room so fast. They were so happy to have not gotten an acquittal on all three counts that they just couldn't be they couldn't be beside them. They were beside themselves. They didn't know what to do. All right, so defense counsel's silence, despite ample opportunity to be heard, is deemed consent. So their silence is apparently consent, even though when were they supposed to say something? She rushed them out of there so fast. When trial judge own on own intuitive declared mistrial, defendant's silence was deemed consent where there was ample time to object despite not being directly asked by the judge. There wasn't ample time in this case. There wasn't ample time. That's the problem. Silence was not consent where judges' conduct was so intimidating to defense counsel as to foreclose any objection from defense counsel to the declaration of a mistrial. Even assuming arguendo, we got to look that up. Hold on. Aha. I mean, I figured something along these lines. So basically, arguendo is a Latin term that means for the sake of argument or in arguing. It's often used in legal settings. Can I help you? My dog is staring at me. It's getting close to dinner time, so they're getting annoyed with me. All right, so even assuming arguendo that the defendant here did not consent to the mistrial, the law is clear that a retrial is permissible so long as there was manifest necessity for the mistrial. The trial judge's belief that the jury is unable to reach a verdict has long been considered the classic basis for a proper mistrial. But that's fine if that were the case, but that's not the case in this point. In this particular case, that's not the case in this case because they weren't hung on all of the charges. But you know what? Canoni just wants to be difficult, I think. I just don't think that she likes Karen. I think well, no, I think she's partly corrupt, but I also think she doesn't like Karen. Just the contempt that she has for them, just the way that she talked to them the whole trial. And I've seen it leading up to the trial in all the pre-trial hearings and things. So, I mean, her contempt and her anger and her disgust just comes off when she talks to them. And I can't stand people like that. Anyways, all right, so the trial judge's belief that the jury is unable to reach a verdict has long been considered the classic basis for a proper mistrial. Describing hung jury as prototypical example of manifest necessity. Because the court here had no doubt based on the jury's notes to the court that it was unable to reach a unanimous verdict, and the jury represented to the court that continued deliberations would be futile, there was manifest necessity for the mistrial based on the deadlock. Right, there was manifest necessity for count 2, but not for counts 1 and 3. And that's the difference, and that's not what they're not distinguishing it that way. And they really need to. And this is absolutely going to get overturned. And I cannot wait until it does. And I hope Judge Canoni loses her position because she should no longer be a judge. As stated above, the foreperson on behalf of the jury in this case sent the court 3 notes, none of which indicated agreement on any of the charges. In the first note, the jury wrote that they had been unable to reach a unanimous verdict. In the second note, they stated that they were deeply divided by fundamental differences in our opinions and state of mind, and that consensus is unattainable. In their third and final note, after they had been given the Tui Rodriguez instruction, the jury stated that they continued to be at an impasse. They described themselves as starkly divided on their perspectives on the evidence, explaining, some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond the reasonable doubt. Why does she keep repeating the same stuff over and over again? Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. The only reasonable interpretation of these notes, and specifically the final note, was that the jury could not agree on any of the three charges and further deliberations would serve no purpose. Given the care that went into writing the notes and how articulately they expressed the jurors' disagreement, it strikes the court as odd that there was no inkling of an indication of agreement in the content of the notes, or that if the jurors were uncertain whether they should return a partial verdict, they would not have asked the court. Well, they didn't know how to ask the court, because how do you ask that in a note without like, how do you, I don't know. I think they were expecting her to confirm at the end, is this how you feel on on all the counts? And somebody, the foreman would say no, like in the Karen Swift trial. In the example that I just showed you earlier. So, anyways, for the defense to now claim that the notes were susceptible to different interpretations, such that the court should have inquired further, rings hollow. This is a weirdly worded sentence. Let me start over. For the defense to now claim that the notes were susceptible to different interpretations, such that the court should have inquired further, rings hollow, particularly where Attorney Yannetti had twice argued that the jury had engaged in due and thorough deliberations and could not agree. But that's not the point. And this isn't, it's like they're not seeing the forest through the trees. Like, we're asking them for this thing and they're still talking about this thing over here, and it's not the same. It's me riled up. All right. So, for the defense to now claim, blah blah blah, particularly where okay, I read all that. All right. No abuse of discretion in declaring a mistrial, given the increasingly adamant manner in which the jurors announced that they were deadlocked. Moreover, defense counsel's conduct immediately after the declaration of the mistrial in no way suggests that they thought otherwise. Okay, but again, it's her job to ask, not theirs. It's her job to make sure that the jury instructions are clear and that the forms are clear and can be easily filled out without confusion. That's her job. So she's putting it all on the defense, but this is, I mean, obviously we know she screwed up, and this is just more of her trying to dig deeper and say, nope, I'm in the right and you're in the wrong, and the Commonwealth versus Karen Reed, we're right, she's wrong. Let's burn the witch at the stake. Jesus. All right. The defendant contends that the court failed to carefully consider that as an alternative to a mistrial, it could have simply asked the jury to specify the charges on which it was deadlocked. Defendant Karen Reed's motion to dismiss at 8. However, the question whether a mistrial is appropriate in the circumstances of a given case is not answered by application of a mechanical formula. Illinois versus Somerville. Rather, the court considers several facts, such as the statements in a jury's note concerning their ability to reach an agreement, the time spent in deliberations, and the length and complexity of the trial. We have never required a trial judge, before declaring a mistrial based on jury deadlock, to force the jury to deliberate for a minimum period of time, to question the jurors individually, to consult with or obtain the consent of either the prosecutor or defense counsel to issue a supplemental jury instruction, or to consider any other means of breaking the impasse. Oh, where here the jury had been deliberating 5 days had returned to the court 3 times stating that they could not agree, had been given the Tui Rodriguez instruction, and returned hours later with a note plainly indicating that they could not agree as to the elements of the charges and that to continue to deliberate would be futile, asking the jury on which charges they were deadlocked was not necessary to determine that there was manifest necessity for a mistrial. Are you kidding? It's not necessary to ask. It's not necessary to determine each charge individually when someone's life is on the line and their freedom. God, I hate this woman so much. Where final note from the foreperson unequivocally stated that the jury was unable to come to a unanimous decision, the judge was not required to inquire whether there were any reasonable probability of unanimous verdicts or if the jury would consent to further deliberations. The judge did not err in declining to poll jury on whether further instructions or deliberations would be likely to resolve a deadlock. Well, no, it's not to resolve a deadlock. You're not trying to resolve a deadlock. You're trying to see if they came to a conclusion on any of the charges. Moreover, the defendant's argument ignores the fact that one of the 3 charges had lesser included offenses. Therefore, if upon questioning the jury had indicated to the court that they were not deadlocked on all the charges, the only option would have been for the court to send the jury back to further deliberations. Such action would be improperly coercive under the circumstances. It had been repeatedly recognized that deadlocked juries are particularly susceptible to coercion, according to Roth, where the jurors have twice reported themselves deadlocked and have already heard the Tui Rodriguez charge. A judge's inquiry concerning partial verdicts cannot avoid communicating to the jury the judge's desire to salvage something from the trial. Where here the jury had before it one indictment, which included lesser included offenses, had 3 times reported themselves deadlocked on separate charges, had already heard the TUI charge, and had sent a final note indicating that continued deliberations would only serve to force them to compromise their deeply held beliefs. Sending them to deliberate further would have been improperly coercive. We're not asking you to send them back. God. Okay. The defendant's argument suggests that questioning or polling jurors who report a deadlock is best practice or at least commonly done by trial judges. However, the defendant has not cited any cases saying as much, and indeed, such an inquiry is not undertaken in the regular course. According to what? The defendant relies on Commonwealth versus Foster and Commonwealth versus LaFontaine to argue that there would be nothing coercive about asking a jury reporting a deadlock whether they had reached a unanimous verdict on any of the counts. Because neither of the jury in Foster nor the jury in LaFontaine reported being deadlocked in its deliberations, and none of the offenses charged had lesser included offenses, there was clearly no risk of coercion in the courts seeking partial verdicts on the separate indictments in those cases. The circumstances here are markedly different. Whatever she says. All right, so where were we? For a judge to make such an inquiry on her own accord would impede upon the strategic decision of counsel to not make such a request. No, it doesn't. So did that guy in Tennessee, the Karen Swift trial? Did that judge do something wrong? Did he impede upon counsel's right to make the request? I mean, seriously, this is her argument. The defendant's argument is based on hindsight. No one other than the jury knew that questioning the jurors as to their deadlock would have yielded a favorable outcome for the defendant. It is likely for that reason defense counsel consented to the court's declaration of a mistrial. So, shouldn't we clear it up or should we just let it keep going on? Let's just keep trying someone until we get a guilty verdict, which is never going to happen in this case. But, anyways, post trial inquiry. The defendant alternatively requests that the court allow counsel to conduct a post trial inquiry of the jurors to substantiate the existence of an acquittal. Defendant reads motion to dismiss. Such an inquiry is impermissible. No, it's not. Says who? The defendant's argument relies solely on Commonwealth versus McCallop. In McCallop, the Supreme Judicial Court held that the trial court should have allowed the defendant's motion for jurors' names and contact information based on the post trial statement of a deliberating juror regarding racist statements made during deliberations. The Supreme Judicial Court explained the presence of even one juror who is not impartial violated the defendant's right to trial in an impartial jury. Quoting Commonwealth versus McCowan, recognizing that racial bias in the jury system is a familiar and recurring evil that, if left undressed, would risk systematic injury to the administration of justice. The McCulloch court held that the defendant should have been given a fair opportunity to obtain an affidavit from the jurors setting forth with some specificity who among the jurors made statements reflecting racial bias and the statements that were made. The defendant's argument here does not implicate racial bias or her right to receive an impartial trial. Thus, the reasoning the court employed in McCallop does not extend to this case. See Commonwealth versus D. Benedetto, declining to extend racial bias exception in inquiry of jury unanimity. I can say that word, unanimity, because infection of the criminal justice system with racial or ethnic bias is a unique type of constitutional deprivation that requires a vigilant response not warranted in the circumstances presented here. The defendant's request, she's just saying none of these cases apply, but she could be taking one thing out of that case, go like, this doesn't apply. So obviously it doesn't apply in this case. The defendant's request effectively seeks permission from the court to inquire from deliberating jurors that which is impermissible information regarding the substance of the jury deliberations. The secrecy of jury deliberations has served as a bedrock of our judicial system. An inquiry into the jury's deliberative processes would intrude improperly into the jury's function. Commonwealth versus Moore. It is simply not the case, given the consent of the jury's final note to the court, that any inquiry to jurors could be limited solely to the results of the deliberative process and not implicate the process itself. What? So you can't ask them what their verdict was? You're asking for the conclusion, not how they got there. This is what bothers me so much about their arguments. Like, they are arguing apples to oranges. And okay, any inquiry would necessarily require the court to understand why the jury's final note communicated a deadlock on the charges when post-trial certain deliberating jurors are purportedly stating that the jury was in fact unanimous on most of the charges. While the defendant contends that the conflict is reflective of the fact that the instructions given to the jury by the court were confusing, determining whether this is true would necessarily require inquiry into the back and forth among the jurors during deliberations. So you can't ask them if they were too confused to fill out a form to exonerate a person so she doesn't have to go back to court and fight the same charges over again. God, this woman. The judge is precluded from inquiring into the internal decision-making process of the jury as a whole or of the individual juror being questioned. Accordingly, evidence and jurors misunderstood the instructions of the presiding judge cannot be considered. And then she's doing all these like little quotes and citations and things are omitted everywhere. So how do we even know that what she's saying is applicable to what she's trying to argue here. I'm getting really mad. Thus, such an inquiry is prohibited. So she's not even letting them go talk to the jurors to get more information. This is going to get overturned. I hope that they can do some kind of some kind of emergency injunction, appeal, whatever they need to do to get this up and towards the state just Supreme Court, because that is where this needs to go. They need to appeal it, and I guarantee you they are. They've already said so much. All right, so the defense counsel has not cited one case suggesting the post-trial inquiry they now seek is appropriate or that it could change the outcome of the proceedings. Because this is unprecedented territory, that's why. But look at Murdoch. They brought a special justice Toll in from, back from retirement. They brought her in to do a special hearing for Murdoch and Becky Hill and other people to talk about, any kind of jury misconduct that was going on. So if you do it for jury misconduct, why wouldn't you do it for making sure that you're not going to cause double jeopardy on someone in this country? I just don't understand. Like, it's okay to call jurors back for that, but it's not okay in a dire situation like this. Okay, got it. For the reason already discussed, an acquittal of the defendant now on indictments 1 and 3 based on conclusions purportedly reached during the jury deliberation is not possible. Therefore, there is no reason for the court to allow post-trial inquiry of the jurors. No error in denial of motion to subpoena the foreman where process would only serve to impeach jury's report to the judge. Okay, I don't know. Some of those things don't make any sense to me when they throw that in parentheses. All right, so the conclusion and order. This court recognizes that the bar on retrials following acquittals is perhaps the most fundamental rule in the history of double jeopardy jurisprudence. However, where there was no acquittal on any of the charges in the defendant's first trial, there is no risk of subjecting the defendant to double jeopardy by retrial on all the charges. So says Judge Beverly, denied. F you, Bev. F you. So hard. Yeah, so denied. I mean, I don't even know what to say. I'm just so angry. You guys probably feel my frustration reading through that. God, I hate her so much. She's just an insufferable, miserable human being. That was her husband. Oh my God, I wouldn't want to deal with that. All right, anyways, let's move on. Oh, before we get to the Turtle Boy, let's see what this is. Ted Daniels' tweet from earlier today. He said, Reed's attorney, David Yannetti, had previously told me, because this morning when this came out, the attorneys said they had no comment, the defense team. So, but Ted Daniel brought this up that Yannetti had previously told him he expects the decision to be appealed regardless of the outcome, but he would not immediately comment this morning. So, and then you've got, was it Fat Amy? She's funny. All right. I don't know if somebody commented on there. Another thing that I thought was interesting that I was going to read to you here was so Ted Daniel, he was reporting all sorts of stuff this morning on X and everywhere. Make this bigger. All right, so on this is Ted Daniel from Boston 25 News. He says, on July 17th, I requested all of the expenses the Norfolk DA's office incurred in their prosecution of Karen Reed from the arrest through her first trial. I received it less than an hour after the MTD ruling in the motion to dismiss ruling in this case was announced, and I'm going through it now. The DA's office is withholding records of expenditures that disclose confidential investigative strategies and techniques as these materials pertain to an active and ongoing criminal investigation. But as you can see, Bodhi Technology invoices and supporting documentation, Hexordia invoices and supporting documentation. These are all the court reporter, U.S. Davis. That was the veterinary lab that did the DNA testing for dog. So Bodhi Technology did the DNA testing on the tail light and the hair that they said was consistent with O'Keefe's, but that's junk science anyways. All right. So it says records of expenditures that disclose confidential investigative strategies and techniques have been withheld as these materials pertain to an active and ongoing criminal investigation. So how is it still an ongoing criminal investigation? Unless we're talking about Proctor and the MSP officers who are under investigation. Because otherwise, how is it a criminal investigation still? I mean, they think she did it. So why are they still investigating? They think it's case closed for John O'Keefe and how he ended up dead. They think it was Karen Reed. So what's the ongoing criminal investigation? I want to know. All right. So that was Ted Daniel on that. And here's another really quick update. So I've talked about this Canton 9 a long time ago on my channel. It felt like forever ago. So they were a group of 9 individuals who were out one day, just a beautiful day, protesting. And they happened to be across the street from Danny Pizza, which is obviously Chris Albert's place of business. And so Chris Albert, I guess his feelings were hurt that some of the signs said things like Colin was in the house. So, which Colin, obviously his son, who we all think was in the house in 34 Fairview Road that night, well past the time that he said he was there. Um, anyways, so they were holding these signs, and attorney Ken Mello, who was the special prosecutor hired in Aiden's case, in Carney's case, to prosecute him for witness intimidation, felony charges, he called the Canton police and had them go and basically threaten and intimidate the 9 individuals that were protesting. So they came out there. I played body cam. There's body cam of it. They were very kind of weird about it. Like you can't protest here. And trying to tell them that it was against the law. It's like, what? First Amendment rights, mother lovers? Come on now. So why are we getting told by cops in Canton that you can't protest? You can't stand there with a sign peacefully. So anyways, they followed them all back to their cars, got their identities, and charged them. Or s- sent them letters to go before a magistrate. However it works there, I don't know. So they had to go and deal with legal things and deal with all that, but then they never really arraigned them. So they've been waiting all this time to find out, are they going to charge us? Are we, what's going to happen? Are they dropping it? Finally, just this past week or so, they dropped the charges on the Canton 9. And I mean, a huge victory for Canton 9. The court decided or looked at everything and decided there was no probable cause. Okay, great. Well, shortly thereafter, Helena Rafferty, who is the chief of Canton Police, writes in a court document that the Canton Police Department is currently reviewing its ability to appeal these findings. So they want to go and they want to see they're going to look at their possibility to appeal it because it makes them look bad that the charges got dropped, but we're all watching and they should have been dropped in the first place. They never should have come in the first place. She's protecting she's in McAlbert through and through. She's protecting those people. So don't be fooled. Helena Rafferty is a corrupt Canton chief of police who is trying to get charges back on the Canton Nine after a judge just dropped them because they found no probable cause. So that's another thing that's going on. There's just so many things, like little things that happen that I didn't want to do like a whole video on. So yeah, so good. I'm glad we got through a couple of those announcements. And now finally, let's read through the Canton Cover-Up Part 391. Turtleboy interviews Karen Reed, juror. So this was just posted 12 hours ago on Turtleboy's website, his blog. He does a good job with his investigative stories. So let's begin. 2 weeks ago, I received an email from someone claiming to be a juror in the Karen Reed trial. I was immediately skeptical, as there is no shortage of degenerates who would spend their days pretending to be a juror in order to feed me misinformation to see if I'd report it, in the hopes that it would damage my reputation. This juror said a couple of things about clothing they were wearing and other context clues that helped identify them. But Paul O'Keefe and various McAlberts got to see the same jurors I did, so I wasn't convinced yet. Luckily, this alleged juror agreed to FaceTime me, and when I answered the phone, I was staring back at a face that I spent 10 weeks looking at. This juror agreed to speak with me under the condition of anonymity. They are very afraid of being doxxed and attacked by the anti-Karen Reed mob who wanted to share with me what they could without giving up information that would make it easier to identify who they are. I sent them a list of almost 40 questions, most of which they answered. However, the one thing most people want to know about is something they don't feel comfortable talking about yet: specifics of juror deliberations. That may change as time passes. For now, I was able to ask what I could, and they answered what they could. Number one, why did you decide to come forward and speak with Turtleboy of all media outlets? Answer. After the trial, I did a lot of catching up across multiple platforms and sources and realized the way news is reported has changed exponentially over the years, no longer coming from mainstream media alone. You're a gritty and unshakable journalist, despite being perceived as a bit rough around the edges. Above all, you seem to genuinely care about the truth. That was the driving force behind my decision. I mean, what better testimony can you get than the first juror come forward and report on the case, and they come to you and tell you why they come to you? I mean, that's a great testimony, and he should put that all over everywhere. Anyways, all right. So number two, had you ever heard of this trial prior to being called for jury duty? I am sure I heard about it when it happened, but it seemed to be another story like any other you see on the news. I didn't pay more attention to this than I did anything else. Number three, when you got jury duty that day, were you aware that the Reed case was picking a jury? I was aware they were picking the jury, but was still surprised when I was chosen from the hundreds of people they brought in during jury selection. Let me stop that ad. Number four, where did you park and what time did you have to get there every day? We reported each day at 8:30 a.m. and took the bus to arrive for the 9 a.m. start time. I am not going to disclose the location. I assume this location may be used for upcoming trials and it's not fair to future jurors. I think that's a very fair answer. Number five, did jurors have a chance to converse socially during the trial? What sort of things did you guys talk about, and did anyone ever discuss the case? We never discussed the case. We spent a lot of time together during bus rides, lunches, breaks, and tried to maintain some normalcy during this very difficult time in our lives. Our conversations were social, like you would have with anyone you spend time with, discussing how the weekend was, things we had going on outside of court, etc. 6. Did jurors see protesters assembling outside the court every day? There were times where we could hear them or catch a glimpse from the bus, but we couldn't see everything going on outside. 7. How hard was it not to go home and read about the case? Did you have to just stay off the internet and not watch TV at all? To be honest, it wasn't that difficult. I went into this completely impartial, and I felt my job as a juror was to ensure that Karen got a fair trial where only the facts and evidence were considered versus information from outside sources. I took my job very seriously. Karen's life was at stake, and she deserved the benefit of not having outside information or opinions cloud my judgment. And that's a really good juror. That's somebody you want on your jury. That's why she got picked out of the hundreds because that reason right there. Were jurors made aware that that Turtleboy was kicked out of the court for the McAlbert testimony? And she said no, or he or she, I don't know. They said no. Number 9, were you made aware that jurors would not be receiving transcripts during deliberations and would have to rely on their notes? Yes, we were told at the beginning of the trial that no transcripts of testimony would be available and we would need to rely on our notes during deliberations. What did you think of John's mother crying during the trial? Did it seem to influence you or any other jurors? I felt immense empathy for both the O'Keefe and Reed families. The loss of a loved one is not something anyone ever wants to go through, and their emotions throughout the trial were at times heartbreaking to see. While I didn't let that impact me when it came to the evidence being presented, I'd be lying if I said it didn't affect me on a personal level both during and after the trial. John lost his life, a tragedy regardless of what other events may or may not have taken place, and I often felt like that aspect of John losing his life was often forgotten in the midst of the trial. Number 11, what did you think of Judge Canoni? Do you feel like she was partial to the Commonwealth with her rulings or demeanor during testimony? This is a good answer. She was kind to us. She always made a point to remind us to stand up and stretch during sidebars. She kept to the schedules for breaks and lunch like clockwork, and she reminded everyone to keep their voices up so we could leave the AC on. It got hot in the jury box. Sitting in the chair listening to testimony all day is very different from real life. You need to be attentive to catch everything, and you can't get up and move around whenever you want to. It sounds pretty silly unless you experience it, but it's very different when you can't just get up and get a snack, use the bathroom, take a brain break, or get some air anytime you want to. Of course, when we asked for breaks, there was never any pushback, but we were also cognizant of the need to keep things going. At times, I did feel there was a level of professionalism that wasn't being maintained and that the severity of circumstances was not always at the forefront. It bothered me when there was an objection and her response was, I'll let him have that. I think it bothered all of us. I think there was some bias against the defense, particularly Mr. Jackson. Oh boy, did we all see it too. So yeah, if you noticed it, that's good because we all did too. But I also think that there were times that she was hard on Lolly. I don't think so, particularly when it came to repeating questions about well established things already made clear throughout prior testimony. There were times I would glance over and wonder if she was paying attention, but to some extent I can understand that it was hard to stay focused. I struggled with this myself, mainly if it was something we had already seen or heard 8 times, like the weather report, the layout of the waterfall bar, etc. Yes, we all know what the waterfall bar looks like and what the weather was that day. So thank you, Mr. Lolly, for that. 12. Was it hard to stay awake and focus during some of the Lolly questioning of witnesses? This juror has a sense of humor. They say, what, if anything, can I really say about this? You were there, which is hilarious. Number 13, the witnesses What witnesses did you find most compelling? They say the medical examiner. I felt she was a straight shooter and gave the medical opinion based only on the facts. There was no point where I felt her opinion had been influenced by either the Commonwealth or the defense to fit a theory being presented. So, and they were there for, I mean, they were supposed to be, a Commonwealth witness, but the medical examiner, she was kind of non-committal to me though in some ways because I think she knew that it was likely not a car that hit him, but whatever. She didn't come forward. Anyways, 14, who do you think was the most pointless witness? Pointless? The two women that were in Aruba with John and Karen a few weeks prior to January 29th. We all thought that too. And then she says unnecessary or they. I don't know. I keep thinking it's a she, but it's a they. I don't know. Unnecessary. John's niece and nephew. I didn't see any reason why the children were brought into a courtroom to testify after all they had been through. I could be there, or it could be, oh, sorry, it could be that they wanted to be heard, but it felt wrong to have them on the stand with everyone watching. And we didn't get to see them. We heard afterwards how horrific it was and awful just to be sitting there watching the kids' testimony. So, from people that were in the courtroom. So, yeah, they were not necessary. 15. Brian Albert, Brian Higgins, and Michael Proctor all greeted the jury and thanked them after their testimony. What did you think about that? They all went, thank you, and gave him like a weird smile and head nod. These three men were a huge focal point of the trial, so while I wish I could have taken it as nothing more than a polite gesture, I did not. Brian Albert, Brian Higgins, Michael Proctor. Yeah. She or he did not think that their thank you jury was just a kind gesture. 16. Do you find Brian Albert's story believable about not waking up to come outside? I was very torn on this throughout the trial. On one hand, I can understand being pretty drunk, going to bed late, and being deep asleep to the point where nothing wakes you up. But I also find it hard to believe that a first responder's instincts, which are ingrained and become part of who they are over the course of their career, had this much commotion on his front lawn and those instincts didn't kick in at any point. And that's a great point. And that's what all of us were saying. It's like your instinct as a first responder should be to go and help. The fact that he didn't, I think, is consciousness of guilt. But what do you guys think about that? Why he didn't come out? 17. What did you think of Jennifer McCabe's testimony? I found Jennifer McCabe to be very combative, which was off putting. Her demeanor made it difficult to process anything she was saying. Something felt off when she continued to ask to be reminded of statements, events, etc., with evidence of her prior accounts. It felt like she needed reader or reminders of what she had said previously. Duh. That's exactly what she was doing said of what she had said before without trying to without contradicting herself. That's exactly what she was doing. I need to see that. Can I see that? Let me see that. What did you think of Michael Proctor's testimony? Michael Proctor was mentioned every single day of this trial, so to say he was someone I was anxiously waiting to hear from would be an understatement. I was obviously disappointed that an officer of the law behaved in a way that showed so little integrity and didn't uphold their oath to protect and serve our community. While I do not agree with a lot of his behavior when it came to the investigation and understand that said behavior was a critical part of the trial for the defense, I wish it hadn't come down to reading texts in open court where he essentially dehumanized Karen. Yeah, it was pretty disgusting and cringe to listen to. None of that had anything to do with the core facts of the case, but it was a bit eye-opening to hear how investigations are discussed amongst some of our law enforcement. There were many things that didn't add up in his testimony, but that can be said for other witnesses as well. I felt it hurt the Commonwealth that the lead investigator wasn't there to testify solely about the outcome of the investigation, but to testify about his actions or misconduct throughout the investigation. Did you find Colin Albert's testimony believable? I found Colin to be purposely elusive when asked questions that he was prepared for. But when it came to the questions he was not prepared for, the cracks in his testimony started to show. I think we can all agree that none of us has ever slipped on ice while holding a solo cup and broken our fall with just our knuckles. Yes, thank you. Thank you. At least this juror has common sense and a sense of humor. What, if any, sense of humor do you have? Did you believe Colin Albert was inside Brian Albert's house? I know that at some point Colin Albert was in the house. That was proven beyond a reasonable doubt, but whether he was there past the time he stated is not clear. I do put weight on Allie McCabe's seeming to slip up during the part of her testimony where she stated that Colin wasn't in the house when John was. I could believe that is the truth, but that statement also put John in the house, which is something the Commonwealth has said did not happen. Exactly. They're lying. 21. Do you believe Katie McLaughlin's testimony that Karen Reed said I hit him at the scene that morning? I believe Katie McLaughlin believes she heard this, whether it be from her own memory or what she was reminded she heard. However, I did find it hard to believe that of all the first responders on the scene that morning that she was the only one to have heard that statement. But at the same time, there was a lot of conflicting testimony from first responders of what they heard or saw that morning. I didn't put any more weight on this testimony than other testimony related to what people heard or saw. So that's interesting. She really didn't think much of Katie McLaughlin when everybody was like, oh my gosh, she was like the first witness that everybody was like really talking about. Did you believe Lucky Lawfren's testimony? Lucky Lawfren is a very likable man, as is his boss, Michael Trotta. Lucky's testimony appeared to be truthful. It didn't seem to be that he had an agenda, but that he just wanted to share what he knew. Did you feel deceived by the inverted Sally Port video? Yes, very much so. The prosecution's emphasis on this video and its supposed significance in proving beyond a reasonable doubt that nobody was near the damaged taillight was a primary focus throughout the trial. It was a shock to find out that what I believed I was seeing and what I was actually seeing were not one and the same. Did the jury have any idea about the federal investigation? If not, what did you think Ryan Nagel was talking about when he said that he spoke to the feds? What did you think all the references to all the other proceedings that witnesses testified at were in reference to? Perhaps others caught on, but I honestly had no idea. I missed Ryan Nagel mentioning the feds during his testimony, and I assumed the other proceedings were another grand jury or something like that. I had no reason to think there was something as big as a federal investigation going on outside of the trial. Do you feel deceived not being told about the feds? I don't think I would use the word deceived, but I would say misled. Looking back, not knowing the entire scope of what was happening and not having what seemed to be the crucial information likely hindered my ability to see the whole picture. So not having the information about the feds didn't help. It hindered them from being able to get the whole picture of what was going on. If I had known the full scope, the ARCA witnesses would have made more sense, and the things that I thought were important may not have been where I focused my attention, and I may have looked at some witness testimony differently. How could anyone on that jury think that Karen Reed hit John with her car after hearing from the ARCA guys? I can only speak for myself, but you have to understand that we were not told where these witnesses came from. There was a lot of conflicting testimony throughout the trial, specifically regarding IT and accident reconstruction experts. I understood that neither the Commonwealth nor the defense hired them, but I had no idea where they came from. That's interesting that jurors didn't catch on that it was the feds that had hired them. For all I knew, they were two very smart and well-educated people who read about the case online and decided to analyze what happened. I found them credible, but there were things they weren't aware of that I thought were important because Lolly made a big deal about specific things that had nothing to do with science and backing up into an individual the way that they say it happened. So they didn't need that information. But anyways, the positioning of their presence and the information that they had provided to analyze was strange, no doubt, but being hired by the FBI or any other agency never crossed my mind. How did you feel about Brian Albert being in court for closing deliberations? I felt it was inappropriate. He was a key witness and a major focal point during the trial, so I don't think he should have been allowed in the courtroom at any time other than during his testimony. This goes for Jen McCabe and Colin Albert as well, so they didn't like it either. Did you feel that a not guilty verdict for Karen on the manslaughter charge implied that the McAlberts were somehow responsible? This is a tough one to answer. Human nature is to want to be Perry Mason and solve the case, and I wasn't exempt from that. I had times during the trial where I would think, if this isn't what happened, then what did happen? As the weeks went on, I realized that my job wasn't to solve the case, but to focus on the one possibility that was being presented to me. So, no, I didn't feel that a not guilty verdict for Karen implied that any of the Alberts or McCabe's were responsible. Having been back in the real world for some time now, I see that it was very likely the public would have perceived it precisely that way, though. How long did the jury take to reach unanimous not guilty verdict on the homicide charge? What was discussed during deliberations that made jurors change their vote from not guilty to manslaughter? Given that motions on counts 1 and 3 remain outstanding, that this just came out last night, I don't believe anyone would discuss this at this time. Anything related to deliberations and their outcome should be kept outside the courtroom. Now that you have had the time to research the case post-trial, what have been some of the most surprising things to learn about? The amount of people who are invested in this case. I went into this not knowing what a following it had and how much it had taken over social media, podcasts, etc. The federal investigation was also a huge surprise. A lot of things made more sense after learning that. They shouldn't keep that out next time. And finally, do you think Chloe is alive? And this jury hopes so. Here are some questions that were not asked or answered. Would you ever consider coming forward and using your real name? If not, why? Are you in contact with other jurors in the case? Do you know why the juror in red was eliminated? What sort of questions did Lolly and the defense ask you during the voir dire? Did your friends and family know you were a juror? Did they ask you about it? How hard was it to keep your identity a secret? And did you understand did you understand the Jen McCabe search testimony from the three witnesses? Which did you find more compelling and why? Do you believe Karen Reed took the life of John O'Keefe with her car? And uh, has the case changed your attitude and trust towards police? So they did not answer those. These are Turtleboy's key takeaways. Jurors clearly had no idea that the most important witnesses in the case, the ARCA experts, were hired by the FBI. Many believed they were hired by Karen Reed's insurance company. The defense should fight harder before trial to oppose the motion in limine preventing disclosure of the federal investigation during trial. I agree. Juror completely missed Ryan Nagel accidentally mentioning that he spoke with the feds. Not sure what would have happened if Yannetti had asked him to expound on that. I wonder. Doesn't that open the door? Wouldn't I would argue that it did. So why shouldn't witnesses be able to tell the jury who they spoke with about this case? This goes for Lucky Lawfern, who was also questioned by the feds long before state police interviewed him. He was first questioned by the FBI, then by Turtleboy, then by state police. That's the order that went in. The medical examiner was supposed to be a strong witness for the Commonwealth, but ended up being a strong witness for the defense, which that's your case. That's the Commonwealth's case. I mean, the rest of their case is hearsay and statements that aren't even put in police reports. That's your case right there is his injuries, and the medical examiner was a stronger witness for the Commonwealth. The juror clearly felt intimidated by Brian Higgins, Brian Albert, and Michael Proctor, all of whom are cops who addressed them directly. Could have been threatening, could have been like, I know who you are. I see you people. I know you guys. I can find you if I need to. Defense should file a motion to prevent witnesses from speaking to the jury like this and from sitting in on the closing statements. Considering the Sullivan sisters and the kids were only called as witnesses to prove that Karen had motive to take the life of John O'Keefe and that the vote on homicide was 12-0, it wasn't surprising that the juror found them to be the least relevant witnesses. Will the Commonwealth be dumb enough to waste their time with them in trial too? Probably, because Commonwealth's pretty dumb. The fact that this juror reached out to me of all media members and was the first juror to actually talk about their experience as a juror as opposed to the vote count speaks volumes about how I am perceived by the general public and should help me with my bogus witness intimidation charges. Not just that, but I mean, that speaks a tremendous amount of credit towards Aiden for the work that he's done in this case and the fact that the jurors even recognize it. The jurors realize who's for justice and who isn't. So, I mean, that's gotta feel good to know that he's on the right side. The jurors see that he's on the right side, and all this craziness eventually has to stop because the feds have to be coming. You know the feds are watching. I'm sure the feds are watching Canoni too now more than ever. And we can just only wait because investigations from the feds take time and they move at a much slower pace than regular law enforcement because they have to get it right. They have to get their investigation right. So let me know in the comments below what you guys think about Canoni, what you think about this case, what you think about the Judge Canoni's dismissing dismissing the motion to dismiss. And what do you think the next steps are for Karen Reed and her defense team? Let me know in the comments below, and I will see you guys in the next one. Take care. Bye now.